When the matter was being called up, Lordship, I prayed that we'll be filing our affidavit during the course of the day, Lordship. But Your Lordship has made a blunder, Your Lordship, because there's another similar matter, Your Lordship, by the same name where the counsel happens to be the same, Your Lordship.
Oh, you're lucky I haven't signed order 26, filed within 2 weeks.
Much obliged, Lordship.
Yes. Yes.
27.
Where's the authority?
Lordship.
Don't show me Tata Cellular or Afcons.
But before going to the authorities, just to cut short, as far as the amendments is concerned, the first amendment with respect to the bona fide resident of Meghalaya, now that now stands contradictory to this requirement of the Invest Meghalaya policy,
We can't go there, Ms. Nongri. We can't question the policy and the requirements. We can't go there.
I'm not questioning.
We can't make a primary inquiry. We are limited. Judicial review is limited only. The Article 14 is violated.
I'm not questioning. All I'm saying is, that if on these grounds no tenders are rejected on these trading license and this Invest Meghalaya, this matter can be closed. If that much assurance can be given, that no tenders will be rejected on this ground, that we don't hold a registration under Invest Meghalaya.
But that means succumbing to your demands.
Because in the first clause, clause A, subclause 1, they have used the word preferably having the units in the state of Meghalaya. So similarly, they can say preferably having registration. Those who have registration have, those who do not have. We'll face the consequences. 15th.
The date has been extended till 15 October, Your Lordship.
So if they can seek instructions on this, we can come back on the 14th.
Lordship,
in the meantime, we'll submit a tender also.
Para 11 of that judgment, Your Lordship.
Okay.
I know limited. Only thing is that we don't want that there be catalyzation. That's all. You see,
Lordship,
especially
Para 11, Your Lordship. This principle was again restated by this court, and so it was held that the term and condition in the tender are prescribed by the government, bearing in mind the nature of contract, and in such matter, the authority calling for the tender is the best judge to prescribe the term and condition of the tender. It is not for the court to say whether the condition prescribed in the tender and the condition were better than the word prescribed in the earlier tender in petition. It has been clearly held in this decision that the terms of the in petition to tender are not open to judicial scrutiny, the same being in the realm of contract, that the government must have a free hand.
Exactly, Mr. Shulai, what this court is saying, that judicial review is limited to that extent, that, Article 14 is not infringed upon.
Lordship.
See, the thing is that you give the level playing field. See, if we are talking about technical specifications, we understand we will not touch it with a barge pole also. That these are the requirements, we will not touch it. But if the requirements of a general nature require registration from the authority, or without going to the product itself, then maybe like if you create a differential kind of criteria.
No, these are general conditions. These are
right. Then maybe this Article 14 might be infringed. But then if we're not talking, if you say technical specifications, we will not touch it. We are not sitting in appeal.
Lordship, in fact, Your Lordship, that because at the time of the motion, the repreneur is banging upon that local entrepreneur, only the bona fide resident. That has been amended, Your Lordship.
Right. If amended, but the only thing is that
it's still contradicting.
You see, number 3. Registering, if it involves. No, I'm not saying that you have a good case.
No.
Maybe it's just a moot point of consideration because it is in public interest. It's not interest of the petitioner. Remember that. In public interest, there are people who getting these roofing materials, get the best materials. And if to get the best materials has to be, the choice should be widespread.
Correct.
The authority who's purchasing it should have the liberty of choice to get the best materials at that whatever rate, 69 crores. That's the only thing. But if you're limiting it to maybe 2-3 people, then there'll be a catalyzation on rates. And number 2, that's only concern.
Now it has been thrown open, Your Lordship. It's thrown open,
but other conditions still, prohibit.
Lordship, so far that condition under the 2024 policy, Your Lordship, in my humble and respectful submission, Lordship, this is only, Lordship, they are free to come to our state and invest, Your Lordship, so that for to generate employment, to generate revenue to the state, Your Lordship.
No, you understand. That is why I'm saying that is in public interest. See, you have to,
Lordship,
you have to balance it. Balancing it means, number one, yes, this, state entrepreneurs have to be promoted.
Lordship,
And so
yes.
as far as practical, good should be taken from them. But other consideration also in this pursuit doesn't mean that you have, you go to the market, and pay the most price and get the most rotten fish. It shouldn't be like that,
As
You
I
pay
have
top
submitted,
price
Your
and get
Lordship,
rotten fish.
As I have submitted, Your Lordship, in fact, it's now the tender is open to all, Your Lordship. It will be a fair and transparent.
So if
Tender,
that is
Your
the
Lord.
case, my lord, it may be recorded that it's open to us, to all, my lord, and we will not be rejected on this ground.
On that, Lordship,
That you can't
for
give
that
the
is
taking.
for the tender committee to take a call, Your Lordship.
What is this?
That is, Lordship, para 11 and 12.
With regard to technical specifications, there's no quarrel, right?
My lord, I also have Hindustan Development, my lord, 1993. This is the main judgment which talks about, my lord, my lord,
Then, Lordship, I have some more, Your Lordship.
Having some more, having some less will not help the case. It's just that we're all aware about this.
Lordship, para 14, Your Lordship.
Of American, sorry.
This is NG Projects Limited, Your Lordship.
Para 14.
Para 14, Your Lordship.
citation.
22, 6 SCC 127. Lordship, somewhere, even in the case where the High Court is of the primacy,
These are,
settle, Your Lordship.
beaten trail judgments.
Lordship. Then, if Lordship
Reflex
can,
and all this, this national high speed, this
Lordship,
metro
kindly
rail.
come to para 16. And then, Lordship, I'll take to Lordship inside that para 22, Your Lordship. Para 16 of that judgment.
Yes.
If Lordship, I take straight to towards the bottom, Your Lordship, the power of judicial review will not be permitted to be invoked to protect private interests at the cost of public interests or to decide the contractual dispute.
Where are you reading from?
Lordship, in in para 20,
NG projects this case.
Lordship, yes, NG
Right.
project, Your Lordship. And then para 22, Your Lordship, that is has been quoted from Jagdish Mandal versus State of Orissa, Your Lordship. Towards the bottom, Your Lordship, the power of judicial review will not be permitted to be invoked to protect private interests at the cost of public interests.
See, you keep on repeating that it's not a question of this court putting its own tender conditions. Okay? It's just of substituting the conditions that is required. It's just that Article 14, that the money capitalization.
From Karnataka High Court, Your Lordship.
Yes. What does this judgment say? This Hindustan Development Corporation?
My lord, kindly have, my lord, this is the main judgment which has been followed subsequently also, my lord. These are the main principles. Kindly have para 7 onwards. 93, volume 3, no? Page 499. Para 7. It is true, as it is today, that the government is a welfare state and has wide powers in regulating and dispensing of special services like lease, licenses, contracts, etc. The magnitude and range of such governmental functions is great. The government, while entering into contract or issuing quotas, is expected not to act like a private individual, but should act in conformity with certain healthy standards and norms. Such actions should not be arbitrary, irrational, or irrelevant. In the matter of awarding contracts, inviting tenders is considered to be one of the fair ways. If there is any reservation of restrictions, then they should not be arbitrary and must be justifiable on the basis of some policy or valid principles which by themselves are reasonable and not discriminatory. Kindly have para 9 onwards, my lord.
Yes.
It must be mentioned that at this stage, the validity of the conditions in the tender as such are not questioned. Consequently, the government had the right to either accept or reject the lowest offer but that, of course, if done on a policy, should be done on rational and reasonable grounds. In so and so, this court observe as under: when the government is trading with the public, the democratic form of government demands equality and absence of arbitrariness and discrimination in such transactions. The activities of the government have a public element, and therefore there should be fairness and equality. The state need not enter into any contract with anyone, but if it does so, it must do so fairly, without discrimination and without any unfair procedure. Approving these principles, a bench of this court in Ramana Dayaram Shetty reads, my lord, this proposition would hold good in all cases of dealing by the government with the public, where the interest sought to be protected is privilege. It must therefore be taken to be the law that where the government is dealing with the public, whether by way of giving jobs or entering into contracts or issuing quotas or licenses or granting other forms of largesse, the government cannot act arbitrarily at its sweet will and, like a private individual, deal with any person it pleases, but its action must be in conformity with the standards and norms which are not arbitrary, irrational, and irrelevant. The power of discretion of the government in the matter of grant of largesse, including award of jobs, contracts, quotas, license, must be confined and structured by rational, relevant, and non-discriminatory standards or norm. And if the government departs from such standards or norm in any particular case or cases, the action of the government would be liable to be struck down, unless it can be shown by the government that the departure was not arbitrary, but was based on some valid principle which in itself was not irrational, reasonable, and discriminatory. In Kasturi Lal Lakshmi Reddy versus State of J&K, an order awarding contract by the government to a party was questioned on the ground that it was arbitrary, malified, and not in public interest, and the same created monopoly in favor of that party, and that the contract was awarded without affording an opportunity to others to compete, and the same is not based on any rational or relevant principles, and therefore was violative of Article 14 of the Constitution and also the rule of administrative law, which inhibits the arbitrary action of the state. A bench of this court, while approving the principles laid down in the above cases, further observed: though ordinarily a private individual would be guided by economic considerations of self-gain in any action taken by him, it is always open to him under the law to act contrary to his self-interest or to oblige another in entering into a contract or dealing with his property. But the government is not free to act as it likes in granting largesse, such as awarding of a contract or selling or leasing out its property. Whatever be its activity, the government is still the government and is subject to restraints inherent in its position in a democratic society. The constitutional power conferred on the government cannot be exercised by it arbitrarily and capriciously or in an unprincipled manner. It has to be exercised for the public good. Every activity of the government has a public element in it, and it must therefore be informed with reason and guided by public interest. Every action taken by the government must be in public interest. The government cannot act arbitrarily and without reason, and if it does so, its action would be liable to be invalidated. If the government awards a contract or leases out or otherwise deals with its property or grants any other largesse, it would be liable to be tested for its validity on the touchstone of reasonableness and public interest. And if it fails to satisfy each test, it would be unconstitutional and invalid. Now, coming to the test of reasonableness which pervades the constitutional scheme, this court in several cases, particularly in reference to Article 14, 19, and 21, has considered this concept of reasonableness and has held that the same finds its positive manifestation and expression in the lofty ideal of social and economic justice, which inspires and animates the directive principles, and Article 14 strike at arbitrariness in the state action. White so and so. So, this is the main judgment which lays down the principle. So, even if there's a policy, the policy itself cannot be arbitrary. In this case, I'm not saying the policy is arbitrary, but I'm saying the policy does not say so that you restrict. The policy says so that...
We won't go to the policy.
We won't go there, my lord.
Policy is their policy. The only thing is that arbitrariness or discrimination that has been called. That's the only thing.
And also, my lord, yesterday, what we've done is from the central government portal, we have put a query regarding whether this aluminium roofing sheet is part of the MSE Act or no, my lord. My lord, we've got a reply to our grievance, my lord, and they say it is not in the list of the MSE, my lord. MSME, my lord, Act. If your lordships wants to have a look at the...
So you see the only three manufacturers. One is Power Roofings, Bernihard, Mariam Commerce.
Three of them, my lord.
Three of them, lordship.
What is your company called? What?
My lord,
What's your brand name?
brand name, my lord. Manaxia is the name of the company, my lord.
What's the brand name of your roofing?
Brand name, I'll just find out, my lord.
Because I don't think.
My lord, aluminium, my lord, and steel is a large industries, my lords. We produce, my lord, aluminium and steel. These...
You produce aluminum and steel.
Yes, my lord. We're a proper manufacturing unit. These
We're not saying
units...
You're not. We're not saying you're not. We just want to see whether you're you're a known brand. That's all the scope
Yes,
of
my
it.
lord.
Going beyond the brief, of course. Those are only the judgments you have.
Lordship, I have some more, lordship. Lordship, satu Karnataka.
Lord, I'm informed that our brand is called Malco, M-A-L-C-O, my lord.
M.A.
N-O-M. Malco, M-A-L-C-O.
Malco.
Yes, my lord.
You've heard of Danaru, you've heard of Dura Color, you've heard of Tata Blue Scope, heard of Danaru. I've never heard of Malco. What is this, Mr.
Lordship, this is Airport Authority of India, Lordship, para 29, your Lordship. Relevant para, your Lordship, is para 30, your Lordship. From the above decision, the following principle emerge. The basic requirement of Article 14 is fairness in action by the state and non-arbitrariness in essence and substance is the heartbeat of fair play. These actions are amenable to judicial review only to extent that the state must act validly for a reasonable reason and not whimsically or for any ulterior purpose. If the state acts within the bound of reasonableness, it would be illegitimate to take into consideration the national priorities. Then, your Lordship, at C, in the matter of formulating condition of a tender document and awarding a contract, greater alternative is required to be considered to the state authorities unless the action of the tendering authority is found to be malicious and a misuse of its statutory power interference by the court is not warranted. Lordship, then, if this certain condition or qualification of have to be laid down to ensure that the contractor has the capacity and the resources to successfully execute the work. If the state or instrumentalities act reasonably, fairly, and in public interest in awarding contract, intervention by the court is very restrictive since no person can claim a fundamental right to carry on business with the government. In the aforesaid decision, it is further observed that the government and their undertaking must have a free hand in setting terms of the tender, and only if it is arbitrary, discriminatory, malified, and actuated by bias, and the court must interfere. It is further observed that the court cannot interfere with the term of the of the tender prescribed by the government because it feels that some other term in the tender would have been fair, wiser, or logical. Lordship, my humble and respectful submission, Your Lordship, there is no the tender condition, Your Lordship, are fair, Your Lordship. It's not discriminatory or arbitrary, Your Lordship.
Who is suppliers last time?
Your Lordship, that I have not taken this. Then, Your Lordship, if Lordship permits, Your Lordship, there is a decision from the Madhya Pradesh, Jharkhand High Court, Your Lordship, on this, more or less on the same issue, Your Lordship. Lordship, I am taking a Lordship straight away to paragraph 49 of that judgment. Lordship, that is the reiteration, Your Lordship, of those decisions which I have relied, Your Lordship. Then, Lordship, para 59.
1 second. Upon Michigan rubber. Yeah, same one.
Lordship,
Uniform.
if Lordship kindly come to para 59 of that judgment. Further. May I read it, Your Lordship? Further, it needs to refer here that it is settled principle of law that the bidder tender cannot be permitted to challenge the bid condition clause which might not suit him and or convenience to him, and the authority floating the tender is the best judge of its requirement, and therefore the court interference should be minimal. Reference to the in this regard may be made to the judgment rendered in the case of so and so, wherein paragraph 9 has been held. Now, so far the imputed judgment and order passed by the High Court dismissing the writ petition is concerned, what was challenged before the High Court was one of the tender condition clause. The High Court has specifically observed and noted the justification for providing clause so and so. The said clause was to be applied to all the tender bidders. It cannot be said that such clause was tailor-made to suit a particular bidder. It was applicable to all. Owner should always have the freedom to provide the eligibility criteria and or the term and condition of the said bid unless it is found to be arbitrary, modified, and or tailor-made. The bidder tenderer cannot be permitted to challenge the bid condition clause which might not suit him and or convenient to him as per the settled proportion of law as such it.
No, again, no, it's again, Mr. Shula, you see, regarding other conditions of tender, regard the requirements which are technical nature, what you need, that no one will interfere. But only with that, the only concern is that see the mega only 3 manufacturers.
Lordship, as I have submitted earlier, Your Lordship, clause one of the tender that has been made all India, Your Lordship, citizen of India. So a person
it can't be a dead letter, no? It can't be a dead letter in the sense that you make it open and then you open from here and the back door.
No, I don't think I don't think that would happen, Your
case,
Lordship. Because, Your Lordship, now a person from Assam also is even, Your Lordship, I've gone through even, Your Lordship, when that clause only with the bona fide resident of Meghalaya is there in the tender, Your Lordship. 3% from Assam also took part in the tender process. Your Lordship.
Taking part is different.
And
being
rejected
is
is different.
Lordship, so far a rejection or acceptance of the tender, Your Lordship, in my humble and respectful submission, Your Lordship, the tender committee would take a call on that, Your Lordship.
Exactly, that's why. See,
Lordship.
what makes the case different that it has come at the initial stage. You don't want to keep on repeating ourselves. With one condition which, like specifically oust all other bidders. That's the only thing.
Now the petitioner, as I have submitted earlier also, Your Lordship, now he's free, now he is competent,
He's
Your Lordship,
ousted,
to apply.
Fine.
He's
Fine.
competent to apply, Your
No
Lordship.
one is prevented from making a bid, but provided a bidder wants to be eligible, right? He can't be disqualified not having the required turnover. He can't be disqualified, he doesn't have required turnover, he bids, he can bid. But the once tender committee says that he doesn't have required turnover, it goes.
I don't think, Your Lordship, because I don't think they will.
And here also, if the one
is-
thing is that you have to register with the Meghalaya MIIPP, you're not registered, so find out.
Lordship, even now also he can go for, Your Lordship.
No, it
Lordship,
cannot. It's
so
not
far, Your
possible.
Lordship. So my humble and respectful submission,
I'll make
Your
an
Lordship,
observation.
whether
Register on 14 morning, since the bid still 15.
Whether, Your Lordship, whether those
Yes,
those
right, take
conditions,
down.
Your Lordship.
Take down. Where's the thesis order?
Then, if Lordship permit, Lordship, there is another decision of
Yes,
also
we'll
from the
take a
Karnataka
call
High
on-
Court, Your Lordship.
We just take a call. We just make an open-ended query to the respondents. That's the only thing. Right?
Lordship.
Yes, we can't drag this matter on for so long. Yes. Take down. Pursuant to the institution of instant writ petition, whereby the writ petitioner had assailed certain conditions given therein, such as What conditions you challenge with the representation, such as clause number
Page
1,
13, Your Lordship.
clause number 1
1, Your Lordship.
of the NIQ with regard to residency in the state of Meghalaya. Clause A bracket capital 1, having their manufacturing units stroke industries in the state of Meghalaya. Clause A capital A, then 3 Roman in 3 open bracket 3, then with regard to registration under the MIIPP, then comma, clause A bracket 6, registration certificate with MIPP, MIIPP. Clause A bracket 13, trading license from the District Council. Problem? Seals and conditions given in NIQ, such as what? What's clause 1 NIQ? Clause number 1, comma. Yes. MIIPP. Yes, trading license from the council. Stop. The state respondents have come up with a corrigendum whereby clause 1 has been relaxed to include bona fide citizens of India, comma, clause A, then bracket 1, change to preferably having their manufacturing units stroke industries here in Meghalaya have been inserted. But however, with regard to the other requirements, that is registration number and registration certificate, and also trading license, registration number registered with MIIPP and trading license, the conditions remain the same. Next para.
Lordship, if I'm so far, the trading license, Your Lordship, in the original clause, Your Lordship, there is a requirement certificate from the past 3 years that has been done away with.
Trading license.
Trading license. Now, what is the requirement? Only a trading license that past 3 years experience is not necessary anymore.
3 years experience and what?
Lordship, kindly, if Lordship kindly.
They didn't challenge 3 years experience.
No, Your Lordship, there is a clause in the original clause. Non-tribal should furnish trading license from concerned district council and income tax clearance certificate from the last 3 years. That has been done away, Your Lordship. Straight away, non-tribal petitioner should furnish trading license from concerned district council. So it has been amended,
Okay.
Your Lordship, modified.
and but however to go up from record but however with regard to a registration number and certificate with MIIPP and trading license are part of doing away with the 3 prior years of possessing one. No other change has been affected. Stop. Next paragraph. It is a pointed submission and stand of the petitioner that notwithstanding the amendment of the NIQ at clause 1 and clause A in bracket 1, which would make them otherwise eligible, comma, the presence of mandatory registration with MIIPP effectively bars the petitioner from submitting its bid, inasmuch as to avail of registration or not inasmuch as to be registered, an entity or company has to have what is a manufacturing has to have
Manufacturing unit.
manufacturing unit in Meghalaya. Next paragraph. Mr. N.D. Shulai, then EAG, in his reply, has submitted that there is no bar for the petitioner to submit its bid, and that acceptance or rejection of the bid will be consequent upon the examination of the same by the duly constituted tender committee. Stop. With the relaxation of clause 1, with the relaxation of the clause with regard to residency and manufacturing unit he submits, the petitioner should no longer be aggrieved. Stop. He has further contended that the prescription of eligibility criteria being within the exclusive domain of the owner of the work and the owner of the work, no judicial review is called for. Stop. Next paragraph. Having heard the counsel for the parties, the only doubt that remains in the mind of the court is to whether the amended clauses as inserted have altered the eligibility criteria, or whether with the retention of the requirement for registration with MIIPP, the restriction still prevails. Stop. Though no doubt the court cannot sit above the though no doubt the court cannot substitute or prescribed clauses over and above the conditions prescribed in the tender, comma, the only concern is that Article 14 should not be breached. Should not be breached, and to ensure that there's a level playing field without any hint of cartelization, CRTLISation, or limiting the bid to such an extent that the same will be the exclusive domain of a few manufacturers. Another thing. Though it is not public interest that such projects be stalled or held up by orders of the court or otherwise, this court, however, deems it fit at this stage itself to direct the state respondents to clarify this position on the next day. Keeping in view the fact that the last date of submission of bids as per the NIQ is fixed on 15 October at 2 p.m. Let this matter appear on October 14th in the motion column itself for further consideration. Don't let query whether it effectively blocks them or not, that's all.
Lordship, if we have this copy of this order, Your Lordship.
A copy of the order be made available to the learned AAG for onward transmission
Lordship.
to concerned respondent. Just that.
Lordship.
Because you see, we're not going to substitute your clause
Lordship.
anything.
Lordship.
But just that it's all done public interest.
Lordship,
The
yes.
poor people is going to the BPL people. Where
Lordship.
the roofing is going to be distributed. It should not be given something that's like, you know, the one wind comes and you see they torn up like paper. You know? Like if the state has to get, you're spending so much money, should get the best stuff, you know, for these poor people. They're getting 2-3 bundles. They'll make the small houses. One cyclone comes doesn't mean that, you know, it becomes like that, like paper tissue or something like that.
Hearing?
But that's what you see in the news all the time. One cyclone, all those ones where they put with bamboos all torn up like
Lordship, I'll not make comment, Your
We
Lordship.
cannot make comments, but we don't want that to happen. We're not seeing it happen, but we don't want that to happen. Yes.
Highly obliged, Your Lordship.
I think Mr. Singhan will have to take this. He's very tired, Mr. Nobri, doing so much research.
I was going to say that.
Yes. We'll have it immediately because you can't.
Yes,
This matter is interesting also. Yes, on the request and counsel of the parties after winter vacations and so and so.
Obliged.
Other hearings? Anyone interested?
34? 34?
Yeah, please, Your
You
Lordship.
ready?
Your Lordship, in pursuance to this court's order on the 13-9, Your Lordship, the SP, Your Lordship, had sent another reminder, Your Lordship, to the FSL at Guwahati, Your Lordship. So we'll be requiring some more time, Your Lordship, to get the report, FSL report.
Yes, MS Ailingwa submits that person to the order of this court dated 13/9/2024. Necessary action has been initiated by the Superintendent of Police.
Yes, Your Lordship, Superintendent Reboy
By the
District. Superintendent of
District.
Police.
And further outcomes is awaited. Yes.
Obliged, Lordship.
List after 2 weeks, yes.
35? 35? Your Lordship, I pray if this matter may be taken up after Puja vacation, Your Lordship.
Your Lordship.
Yes.
My Lord, I am for the petitioner. My Lord, my simple prayer is for the invalid pension, my Lord. So this matter may be taken after 3 weeks, my Lord.
In disability pension?
Yes, Your Lordship.
Yes, the request of party, that's a matter for 3 weeks. Yeah.
36?
Much obliged, Lordship.
36?
My Lord, this is a case with regard to that three houses were socially boycott from the village.
My Lord, at one point of time, this Honorable Court has expressed an
Views
opinion,
for-
views for sending this matter for mediation. We were open for that, my Lord.
We would like,
For
my Lord.
mediation?
Yes, my Lord.
What is the pointed issue here that remains for?
Remains not only that the three impunge order issued by the respondent
That
number
your
5.
house been blocked?
No, not
no,
no.
no.
We were socially boycott from the village.
The dream one.
Yes.
Yes, yes. my Lord.
Then which mediators is be feasible to handle this kind of? Anyway, please
My Lord, if this honorable court is pleased to constitute the mediation.
As the matter is concerns a social problem, at this stage the parties submit that perhaps if the matter is sent to mediation, the same can be resolved. Yes, accordingly, this matter for the mediation committee for placing for mediation with due notice to the parties. Yes.
Obliged.
40? 40?
Obliged, Lord.
Your Honor, I would like to pray some time on this matter. Mr. Yoben had to go for some urgent family matters.
So this is the matter involving the headman, my lord, where I was not granted NOC and a letter was written to the...
Yes, where's Mr. Euban?
He had
The
to
headman
run for-
said I am a superior authority to the government registration authority. He is the one who said that.
above the code as well, because we have a degree.
Over the registration act, over the
Over
evidence act
everything, my
also.
lord, it seems.
Yes.
Well, then in
Even
that...
if registered deed will not be accepted by him.
No, my lord, my lord, interestingly, my lord, what the headman has done is one thing, my lord, but what the state also has done is, my lord, on the basis of that letter is refused.
State-
When I have a degree in my, my lord, what else, what more do I need to
Is,
submit?
Anyway. He's coming back here now.
No, my lord.
Gone home.
Yes, he had for some family matters, my lord.
He's saying there's some emergency, my lord. I was also. We'll have it after a week in that case, my lord. Well, only one prayer, my lord. It cannot be on except 15, my lord. If lordship, I can make that prayer. We'll have it on the 16th.
It's a
my lord.
matter after so the prayer of the parties. Yes.
Much obliged. Much obliged.
41?
Please, Your Lordship. Lordship, I'm praying for 2 weeks accommodation, Your Lordship.
Become a journal specialist now. I think should be paid more than arguing counsel. You tell your senior, say my fees should be raised. No? Yes or no? Yes. After 2 weeks, the request of counsel petitioner.
42?
Transfer.
Lordship, this matter is fixed for submission of written
yeah.
arguments,
It's
Lordship.
all ready.
Your
Bullet
Lordship,
points.
we're
Lordship.
praying for a week's time, Your Lordship.
Lordship, written arguments
We'll
is
be
ready,
filing it
Lordship.
after the...
If you don't post the matter, no one files it. You keep it there.
Your Lordship,
Post after
will
1
be-
week filing bullet points.
Lordship.
State respondents pray for a lot for the 1 week's time. You file bullet point this after a week. Because otherwise, they don't file it.
Yeah,
So
please,
the
Your
other
Lordship.
one they didn't file. That state didn't file the other one today. That grow what energy co or something. They have not filed. Who's the counsel appearing? Colney. Huh? No, SM Energy Co. No, the thing is that, see, since like we're having 2-3 holidays, then we can complete those CAVs, but
Your Lordship, if I may, Your Lordship, I'll be filing on behalf of the District Council, Your Lordship.
wait till the next date.
Till the next.
Enjoy your pujas this
Like
holidays, yes.